Dear aspirants, welcome to our next lecture of international law. Today, we will discuss our next topic, which is state in general and recognition. Now, coming over to the outline of our today's topic. Personality and statehood in international law, the subjects of international law, recognition and modes of recognition, theories of recognition, recognition of state and government in international law, recognition of state and government in national law. We will discuss all of the headings one by one in detail. So, the first heading is state in general and recognition. A state is a sovereign political entity that exercises control over a defined territory and population. It is typically composed of three elements: a government, a population, a defined territory. Definition of state. Now, definition of recognition. Recognition is the act of acknowledging the existence and legitimacy of a state. Recognition is typically granted by other states, but it can also be granted by international organizations or non-state actors. A state that is recognized by other states is said to be a recognized state. Now, importance of recognition. Recognition is a crucial aspect of international law, as it determines which states are considered to be legal actors in the international system. Recognition can be an important factor in resolving disputes between states, as it can establish the legal status of a state and its government, and it can also affect the jurisdiction of international courts and tribunals. It also has an important role in the process of state building and nation building, as recognition can facilitate the integration of new states into the international community. Now, discretion and recognition. Recognition is not automatic, and states have discretion in recognizing other states. Recognition can be formal, in the form of a diplomatic exchange of notes, de jure, or informal, in the form of de facto recognition. Recognition of a state does not necessarily imply approval of its government or policies. It is simply an acknowledgement of the state's existence and status as an independent and sovereign entity. Now, the next heading is statehood and personality in international law. Definition of statehood. Statehood refers to the status of an entity as a recognized sovereign state in the international system. In order for an entity to be considered a state, it must possess certain characteristics such as a defined territory, a permanent population, a government, and the capacity to enter into relations with other states. The concept of statehood is closely related to the principle of sovereignty, which is the principle that states are supreme within their own territory and are not subject to the authority of other states. Now, definition of personality. Personality refers to the legal capacity of an entity to act as a subject of international law. It includes the ability to enter into treaties and other international agreements, the ability to bring and defend claims before international courts and tribunals, and the ability to participate in international organizations. Personality is not dependent on statehood, and entities such as colonies, territories, and organizations can possess personality in international law. Relationship between statehood and personality. Statehood and personality are closely related concepts in international law. Statehood is a necessary prerequisite for the exercise of sovereignty and for the participation of an entity in the international system. Personality is the legal capacity of an entity to act as a subject of international law, but it is not dependent on statehood. An entity can possess statehood, but not possess personality, or vice versa. Now, coming over to the examples of statehood and personality. Pakistan is a recognized sovereign state under international law, possessing the characteristics of statehood, and has legal capacity to enter into treaties and other international agreements, bring and defend claims before international courts and tribunals, and participate in international organizations. The colony of Hong Kong, before 1997, was not a sovereign state, but it possessed personality in international law, as it entered into treaties and other international agreements, participated in international organizations, and could bring and defend claims before international courts and tribunals. Now, recognition of statehood. Recognition of statehood is the process by which other states acknowledge and accept the existence of a new state. Recognition is important because it grants the new state access to the international community and the rights and responsibilities that come with it. Recognition can be either de jure, meaning formal recognition by other states, or de facto, meaning recognition in practice. Recognition is not always automatic and may be dependent on certain conditions or negotiation. Now, challenges to statehood and personality. There are various challenges to the concept of statehood and personality in international law. such as the emergence of new entities such as virtual nation-states, supranational entities, and non-state actors. There are also challenges to the recognition of statehood, such as disputes over territory or self-determination. These challenges have led to ongoing debates and discussions in the international community about the definition and criteria of statehood and personality. Now coming over to the references from different books. International Law by Malcolm N. Shaw. Shaw defines statehood as the status of a community as a sovereign and independent state in the international system, 7th edition, p. 18. He explains that for an entity to be considered a state, it must possess a defined territory, a permanent population, a government, and the capacity to enter into relations with other states. He also notes that the concept of statehood is closely related to the principle of sovereignty, which is the principle that states are supreme within their own territory and are not subject to the authority of other states. Shaw also explains that personality refers to the legal capacity of an entity to act as a subject of international law, including the ability to enter into treaties and other international agreements, the ability to bring and defend claims before international courts and tribunals, and the ability to participate in international organizations. Now, the second is Principles of Public International Law by Ian Brownlee. Brownlee defines statehood as the status of a community as a sovereign and independent state in the international system, 8th edition, p. 17. He explains that for an entity to be considered a state, it must possess a defined territory, a permanent population, a government, and the capacity to enter into relations with other states. He also notes that the concept of statehood is closely related to the principle of sovereignty, which is the principle that states are supreme within their own territory and are not subject to the authority of other states. Brownlee also explains that personality refers to the legal capacity of an entity to act as a subject of international law, including the ability to enter into treaties and other international agreements, the ability to bring and defend claims before international courts and tribunals, and the ability to participate in international organizations. The third is International Law by Dr. S. K. Kapoor. Kapoor defines statehood as the status of a community as a sovereign and independent state in the international system, 7th edition, p. 17. He explains that for an entity to be considered a state, it must possess a defined territory, a permanent population, a government, and the capacity to enter into relations with other states. He also notes that the concept of statehood is closely related to the principle of sovereignty, which is the principle that states are supreme within their own territory and are not subject to the authority of other states. Kapoor also explains that personality refers to the legal capacity of an entity to act as a subject of international law, including the ability to enter into treaties and other international agreements, the ability to bring and defend claims before international courts and tribunals, and the ability to participate in international organizations. Now, reference from the last book, which is Introduction to International Law by J. G. Stark, QC. Stark defines statehood as the status of a community as a sovereign and independent state in the international system, 14th edition, p. 17. He explains that for an entity to be considered a state, it must possess a defined territory, a permanent population, a government, and the capacity to enter into relations with other states. He also notes that the concept of statehood is closely related to the principle of sovereignty, which is the principle that states are supreme within their own territory and are not subject to the authority of other states. Stark also explains that personality refers to the legal capacity of an entity to act as a subject of international law, including the ability to enter into treaties and other international agreements, the ability to bring and defend claims before international courts and tribunals, and the ability to participate in international organizations. He also notes that personality is not dependent on statehood, and entities such as colonies, territories, and organizations can possess personality in international law. Let's take a look at the gist from all these referred books. It is worth noting that in all of these books, the authors provide similar definitions and explanations of the concepts of statehood and personality in international law. They all emphasize that statehood is the status of an entity as a recognized sovereign state, and that personality refers to the legal capacity of an entity to act as a subject of international law. Additionally, they all note that statehood is closely related to the principle of sovereignty, and that personality is not dependent on statehood. Now, coming over to the examples of statehood and personality. First, recognition of statehood. The recognition of Israel as a sovereign state by the United Nations in 1948. or the recognition of the State of Palestine by the United Nations in 2012. Challenges to statehood. The ongoing dispute between India and Pakistan over the territory of Jammu and Kashmir, where both countries claim statehood over the region. Examples of entities with personality in international law. The European Union, which has legal personality and the ability to enter into international agreements and participate in international organizations, despite not being a sovereign state. Furthermore, examples of entities without personality in international law. Taiwan, which is not recognized as a sovereign state by many countries, and does not have legal personality in the United Nations. Also, example of state not recognizing another state. North Korea and South Korea. North Korea not recognizing South Korea as a sovereign state. Another example of state not recognizing another state. Taiwan and China. China not recognizing Taiwan as sovereign state. These are a few examples of how statehood and personality can play out in the international arena, and how they can be challenged and debated. Now, the next heading is the subjects of international law. The subjects of international law refer to the entities or actors that are capable of possessing rights and obligations under international law. These are also referred to as persons in international law. These can include 4. 1. States. States are the primary subjects of international law. They possess the capacity to enter into treaties, participate in international organizations, and bring and defend claims before international courts and tribunals. 2. International organizations. International organizations such as the United Nations, World Trade Organization, International Monetary Fund, etc., also possess legal personality and are capable of possessing rights and obligations under international law. 3. Individuals. Individuals can also be subjects of international law, particularly in the context of human rights and international criminal law. 4. Non-state actors. Non-state actors such as transnational corporations, non-governmental organizations, and armed groups can also be subjects of international law in certain circumstances. Now coming over to the references from different books. International Law by Malcolm N. Shaw. The author defines the subjects of international law as entities that are capable of possessing rights and obligations under international law, and notes that this includes states, international organizations, and individuals. He also mentions that non-state actors can also be subjects of international law in certain circumstances, such as transnational corporations and non-governmental organizations. Now, the second is Principles of Public International Law by Ian Brownlee. Ian Brownlee defines subjects of international law as entities that are capable of possessing rights and obligations under international law, and notes that this includes states, international organizations, and individuals. He also explains that the concept of legal personality is closely related to the subjects of international law, as entities with legal personality are capable of possessing rights and obligations under international law. The third is International Law by Dr. S.K. Kapoor. The author defines subjects of international law as entities that are capable of possessing rights and obligations under international law, and notes that this includes states, international organizations, and individuals. He also highlights that non-state actors, such as transnational corporations and non-governmental organizations, can also be subjects of international law in certain circumstances. And the last is Introduction to International Law by J.G. Stark QC. J.G. Stark defines subjects of international law as entities that are capable of possessing rights and obligations under international law, and notes that this includes states, international organizations, and individuals. He also explains that the concept of legal personality is closely related to the subjects of international law, as entities with legal personality are capable of possessing rights and obligations under international law. Let's take a look at the gist from all these referred books. All these books provide similar definitions and explanations of the subjects of international law and the entities that are capable of possessing rights and obligations under international law. They all mention that states, international organizations, and individuals are subjects of international law, and that non-state actors can also be subjects in certain circumstances. Additionally, they all mention that the concept of legal personality is closely related to the subjects of international law. Now coming over to the examples of the subjects of international law. 1. State. The United States, China, Russia, Pakistan, India, Afghanistan, etc. are all examples of states that are subjects of international law and have the capacity to enter into treaties, participate in international organizations, and bring and defend claims before international courts and tribunals. 2. International organizations. The United Nations, World Trade Organization, International Monetary Fund, etc. are examples of international organizations that possess legal personality and are capable of possessing rights and obligations under international law. Furthermore. 3. Individuals. Examples of individuals who have been subjects of international law in Pakistan and surrounding countries include military officials, politicians, and leaders of non-state armed groups, such as Hafiz Saeed, who was designated as a global terrorist by the United Nations and arrested in Pakistan in 2019, and Mullah Omar, the former leader of the Taliban in Afghanistan, who has been charged with war crimes by the International Criminal Court. 4. Non-state actors. Transnational corporations such as Nestle, Pakistan's oil and gas development company, India's Reliance Industries, and Shell. Non-governmental organizations such as Amnesty International and armed groups such as the Taliban and ISIS can also be subjects of international law in certain circumstances. Now, the next heading is recognition. Meaning and definition of the term recognition. Oppenheim defines recognition as, in recognizing a state as a member of the international community, the existing states declare that in their opinion, the new state fulfills the conditions of statehood. It is not a law, it is based on inconsistent practices of the state. Now, the next heading is modes of recognition. Recognition may be of two kinds: de facto and de jure recognition. The practice of states shows that in the first stage, the states generally give de facto recognition. Later on, when they are satisfied that the recognized state is capable of fulfilling international obligations, they confer de jure recognition on it. That is why it is sometimes said, de facto recognition of state is a step towards de jure recognition. We will now discuss in a little greater detail both kinds of recognition. So, the first mode of recognition is de facto recognition. According to Prof. G. Schwarzenberger, when a state wants to delay the de jure recognition of any state, it may, in the first stage, grant de facto recognition. The reason for granting de facto recognition is that it is doubted that the state recognized may be stable, or it may be able and willing to fulfill its obligations under international law. Besides this, it is also possible that the state recognized may refuse to solve its main problems. De facto recognition means that the state recognized possesses the essential elements of statehood and is fit to be a subject of international law. However, the effects of de jure recognition are more far-reaching. In the words of Oppenheim, the de facto recognition of a state or government takes place when, in the view of the recognizing state, the new authority, although actually independent and wielding effective power in the territory under its control, has not acquired sufficient stability or does not yet offer prospects of complying other requirements of recognition, such as willingness or ability to fulfill the international obligation. In the view of Judge Lauderpicht, de facto recognition shows that the recognizing state wants to establish its relations with the recognized state without establishing diplomatic relations. As remarked by Prof. Oppenheim, de facto recognition is, in a sense, provisional and liable to be withdrawn if the absent requirement of recognition fails to materialize. Furthermore, in the view of Judge Philip C. Jessup, de facto recognition is a term which has been used without precision. When properly used to mean the recognition of the de facto character of a government, it is objectionable and indeed could be identical with the practice suggested of extended recognition without resuming diplomatic relations. So, the second mode of recognition is de jure recognition. De jure recognition is granted when, in the opinion of recognizing state, the recognized state or its government possesses all the essential requirements of statehood and is capable of being a member of the international community. As pointed out by Prof. H.A. Smith, the British practice shows that three conditions precedent are required for the grant of de jure recognition of a new state or a new government. The three conditions are as a reasonable assurance of stability and permanence. The government should command the general support of the population. And the last is, it should be able and willing fulfill to its international obligations. Recognition de jure results from an express declaration from a positive act, indicating clearly the intention to grant this recognition, such as the establishment of diplomatic relations. De jure recognition is final and cannot be withdrawn once given. As pointed out earlier, for de jure recognition, an express declaration of the intention to grant such recognition and the intention to establish diplomatic relations are necessary. Now, coming over to the difference between de facto and de jure. De facto, de jure, 1. It is not a permanent status, it is permanent status. 2. Withdrawal is possible, withdrawal is not possible. 3. No diplomatic relation between recognizing and recognized state. There will be diplomatic relation between recognizing and recognized state. At last, reason of de facto recognition, to show a friendly attitude and to assure them that they will be recognized as de jure when gain stability. Now, the next heading is theories of recognition. 1. Constitutive theory. According to this theory, recognition clothes the recognized state with rights and duties under international law. Recognition is a process through which a political community acquires international personality by becoming a member of the family of nations. Hegel, Anzalodi, Oppenheim, etc. are the chief exponents of constitutive theory. In the words of Professor Oppenheim, a state is and becomes an international person through recognition only and exclusively. According to the constitutive theory, statehood and participation in the international legal order are attained by political groups only insofar as they are recognized by established state. In this view, recognition confers maturity upon state, and until and unless a state is recognized, it cannot acquire rights under international law. The practice of states, however, indicates the contrary. In practice, most states accept the declaratory theory. In this connection, Judge Lauderpicht has remarked that the white acceptance of declaratory theory is due to the reaction against the traditional conception of recognition as a political act purely and simply. In his view, there is a legal duty on the part of the state to recognize any community that has in fact acquired the characteristics of statehood. The constitutive theory is criticized, and the criticism is, jurists have vehemently criticized the constitutive theory. The view of Judge Lauderpicht that there is a legal duty on the part of the existing states to recognize any community that has in fact acquired the characteristics of statehood does not seem to be correct. In practice, the state does not accept any such obligation. The practice indicates, however, that although established states normally recognize new states and new governments that exist, they have not consented to law norms that obligate them to do so. Besides this, the constitutive theory presents several other serious difficulties. According to this theory, if a state is not recognized, it can have neither duty nor rights under international law. This is a very absurd suggestion. Now, if we accept this proposition, it will create difficulties in the case of a new state recognized by some states but not by others. Such as, the example of China can be cited in this connection. China was not recognized by America and other Western countries for several years, although China possessed all the essential attributes of a state. But to assert that China, therefore, did not have rights and duties under international law would be an absurd proposition. Furthermore, the second theory of recognition, which is declarative or evidentiary theory. According to this theory, statehood or the authority of the new government exists as such before and independently of recognition. Recognition is merely a formal acknowledgement through which facts are accepted. The act of recognition is merely declaratory of an existing fact that a particular state or government possesses the essential attributes as required under international law. The chief exponents of this theory are Hull, Wagner, Brierly, Pitt, Cobbett, and Fisher. According to Prof. Hull, a state enters into the family of nations as of right when it has acquired the essential attributes of statehood. Furthermore, Pitt Cobbett has expressed the view that the existence of a state is a matter of fact. In his words, so long as a political community possesses in fact the requisites of a statehood, formal recognition would not appear to be a condition precedent to the acquisition of the ordinary rights and obligations incident thereto. Brierly has also remarked, The granting of recognition to a new state is not a constitutive, but a declaratory act. A state may exist without being recognized, and if it exists in fact, then whether or not it has been formally recognized by other states, it has a right to be treated by them as a state. The Soviet view and practice are also in favor of the declaratory theory of recognition. According to the Soviet view, the birth of a state is the act of internal law, rather than that of international law. In modern times, international personality does not depend upon recognition. This theory has also been subject to criticism. The view that recognition is only a declaratory of an existing fact is not completely correct. When a state is recognized, it is a declaratory act, but the moment it is recognized, there ensues legal effects of recognition which may be considered constitutive. Now coming over to the conclusion of both theories. In conclusion, the theories of recognition, namely the constitutive theory and the declarative or evidentiary theory, present contrasting views on the process and effects of recognition in international law. The constitutive theory argues that recognition is the means through which a state acquires rights and international personality, while the declarative theory asserts that recognition is a formal acknowledgement of existing facts. Although both theories have their merits and criticisms, the declarative theory has gained wider acceptance in practice. It recognizes that recognition is important, but not the sole determinant of a state's rights and obligations, instead complementing the factual existence and attributes of statehood. The precise nature and consequences of recognition remain subjects of ongoing debate in the international community. Now, coming over to our second last topic of our today's lecture, which is recognition of state and government in international law. Definition. Recognition of a state and government in international law refers to the formal acceptance by other states of a particular entity as a sovereign state and its government as the legitimate one. Recognition is an important aspect of international law, as it determines which entities have the capacity to enter into treaties and participate in international organizations, and it also has implications for the rights and obligations of the recognized entity. Criteria for recognition. The main criteria for recognition of a state and government in international law are control of a defined territory and a population, and the capacity to enter into relations with other states. A state must have effective control over a defined territory and a population in order to be recognized as a sovereign entity. Additionally, the state must have the capacity to conduct foreign relations, such as entering into treaties and representing itself in international organizations, in order to be recognized as a subject of international law. Now coming over to the political nature of recognition. Recognition is a political act that is based on the principle of state sovereignty, and it is not a legal requirement for a state to be recognized by other states in order to exist. The act of recognition is a political decision made by states, rather than a legal requirement. A state may exist as a sovereign entity without being recognized by other states, but it may not have the same rights and obligations as a recognized state. Now coming over to the lack of clear legal rule. There is no clear legal rule on when recognition should be granted, and it is often based on political considerations. Recognition is not a legal requirement for a state to exist, and there is no set rule or procedure for when a state should be recognized. Recognition is often based on political considerations such as a state's alignment with other states, its human rights record, and its compliance with international law. Now coming over to the examples from Pakistan and other countries. The recognition of Pakistan as a sovereign state in 1947 by the United Nations and other countries following its independence from British India. The recognition of Bangladesh as a sovereign state in 1971 by the United Nations and other countries following its independence from Pakistan. The recognition of the Taliban government in Afghanistan by Pakistan, Saudi Arabia, and the United Arab Emirates during the Taliban regime from 1996 to 2001, despite the lack of recognition by the United Nations and other major powers. The lack of recognition of the state of Azad Jammu and Kashmir and Gilgit-Baltistan by the majority of countries, as they are not recognized as sovereign entities by the United Nations or other major powers, and are considered as a part of Pakistan. The recognition of the government of India by Pakistan and other countries, despite the ongoing disputes over the status of Jammu and Kashmir and other issues. The recognition of Israel by the United States and other countries in 1948, following the establishment of the State of Israel after the end of the British Mandate in Palestine. Furthermore, the recognition of the People's Republic of China by the United States in 1979, following the Chinese Communist Revolution, and the establishment of the People's Republic of China as the sole legal government of China. The recognition of the State of Palestine by various countries, such as Sweden and the Vatican, in recent years, despite the lack of formal recognition by the United Nations or other major powers. Furthermore, the lack of recognition of Taiwan by most countries, as the majority of countries recognize the People's Republic of China as the sole legal government of China. The lack of recognition of the Taliban government in Afghanistan by most countries during the Taliban regime from 1996 to 2001. The recognition of South Sudan as a sovereign state in 2011 by the United Nations and other countries following its independence from Sudan. Moreover, the recognition of the government of the Soviet Union by the United States and other countries in 1933, despite the lack of democratic elections and human rights abuses under Soviet rule. The lack of recognition of the self-proclaimed state of Northern Cyprus by the majority of countries, as it is only recognized by Turkey. The recognition of the state of Eritrea by the United Nations and other countries in 1993, following its independence from Ethiopia. The lack of recognition of the breakaway territories of Abkhazia and South Ossetia by the majority of countries following the 2008 Russia-Georgia war, as they are only recognized by a few countries, such as Russia and Syria. At last, note, the above examples are for illustration purpose only and doesn't reflect any political stance of the writer. Now, coming over to the last topic of our today's lecture, which is recognition of state and government and national law definition. Recognition of state refers to the acceptance and acknowledgement of the sovereignty and independence of a particular state by another state. Recognition of government refers to the acceptance and acknowledgement of the authority and legitimacy of a particular government by another state. Now, coming over to the mechanisms. Recognition can be carried out through various mechanisms such as legislation. Recognition can be made through the passage of laws by the national legislature. Executive actions. Recognition can be made through decisions and actions taken by the executive branch of government. Judicial decisions. Recognition can be made through decisions of the national courts. Now, coming over to the implications. Recognition of state and government can have significant implications for diplomatic relations, trade, commerce, and other areas of international relations. Recognition of the state enables it to interact with other states in the international arena, establish diplomatic relations, and participate in international organizations. Moreover, recognition of government establishes the legitimacy of the government, enabling it to represent the state in international relations. Now, coming over to the examples. International law. Malcolm N. Shaw, in his book, Shaw cites the example of the recognition of Israel by the United States in 1948 through legislation passed by Congress. Principles of Public International Law. Lan Brownlee. Brownlee's book cites the example of the recognition of the People's Republic of China by the United States in 1979 through an executive decision by the President. The third is International Law. Drive. S.K. Kapoor. Kapoor's book cites the example of the recognition of Quebec as a distinct society within Canada by the Supreme Court of Canada. Introduction to International Law. J.G. Stark, Q.C. Stark's book cites the example of the recognition of the State of Palestine by India through an executive decision by the government. Here are some examples that include Pakistan. Recognition of Pakistan by the United Kingdom in 1947 through legislation passed by the British Parliament. Recognition of Bangladesh by Pakistan in 1972 through an executive decision by the Pakistani government. Recognition of the State of Palestine by Pakistan through an executive decision by the Pakistani government. Recognition of the Syrian opposition government by Pakistan through an executive decision by the Pakistani government. And the last is recognition of the independence of South Sudan by Pakistan through an executive decision by the Pakistani government. With this, I come over to the end of our today's lecture. I hope you like and understand the lecture. Like and subscribe our channel, also click the bell icon to get notifications of our videos. I thank you all.